Okay, so George Thomas, one of the co-defendants here, he basically testified against Boyd. He went through and said that he rode with him when he had Newsome blindfolded and bound in Shannon Christian's car. He said that Boyd wanted his help with him, but he said no. He didn't mention anything about Newsome being raped, even though we do know that he was raped. And he said that Boyd marched Newsome off into the dark near a drainage ditch, and he stayed behind. So very interesting things. We're getting more of this account of what happened here to these victims. Tara Walsh, criminal defense attorney, joining us here today. What do you think? You know, as we said, this is supposed to be a big witness for the state. A lot of new evidence, a lot of new accounts coming. Is he holding up to the hype?
Well, look, I mean, once he gets cross-examined, I'm sure this defense attorney is going to go after him and go after him hard on this sweetheart deal that he's preparing himself for, specifically this major reduction in the sentence that he's currently serving. So I'm sure there will be many questions for him about that. If he was prepped by the prosecution in any way, shape, or form, how many times he spoke with the prosecution, if there was any sort of signed agreement memorializing the sentence reduction that he may be receiving in light of the favorable testimony he's giving to the state. So that's number one. Number two, I did not recall hearing that he ever exited this vehicle. This was late at night. He never said that he actually got out of the car. So for him to be divulging so much detail about exactly what happened, the movements that were made, you know, I think is certainly suspect, and I'm sure that the defense attorney is going to get into that on cross-examination.
Absolutely, and going off that, this is all the things that he's claiming now, and some of these things and parts of the story are different from what we heard before from him. So even though he's supposed to be this great witness, his credibility isn't necessarily all that great.
Right, and that'll be another issue that he will face on cross-examination. I'm sure the defense attorney would have ordered a transcript of any prior testimony in the case, and if I were the defense attorney, I would have studied that before going into trial and making sure that I'm pointing out every single inconsistency in his prior testimony with how he's testifying today at this trial.
All right, Tara, thanks. Let's play another piece of his testimony from court. Okay, so we hear more from Thomas where he's claiming that he didn't see Boyd with a gun or have a gun in his hand. He also said that he saw 3 flashes and saw Boyd take Newsome behind a building, and then he heard a whoosh. So a lot of more, you know, interesting parts and details we're getting from this. How is this all going to play into when he gets cross-examined, Tara, when you listen to all the account of what he's explaining here?
Right. So you heard the prosecutor ask him when he first saw the gun, and he actually responds that he didn't see him with the gun in his hands. The prosecutor then asked him, well, when did you first see the gun? There was a long pause from him, and then he actually said he saw him with a gun days earlier. So if I were the defense attorney, I would have jumped on that, and I'm sure the defense attorney will, in that if he didn't actually see him with a gun, how was he able to see all of these other things that he claimed happened? He claimed he saw him actually grab a gas can. He claimed he saw him pull the body out of the car, bring the body behind an industrial building. So it sort of calls into question his credibility with regard to all of these other observations that he allegedly made.
And that seems to be a theme with a lot of these witnesses. A lot of them have now backtracked and said they don't remember things, or especially the ones involved with this house and the ringleader, if you will. So we're seeing that more with other witnesses as well. And when you think about that and take all of that into play here, as we said, his credibility is kind of wavering now.
Yes, I would agree with that, and I'm sure that the defense attorney is going to point that out. You know, there are ways, if a witness is claiming that they don't remember testifying to certain things, of course you can pull out a transcript and gently remind them. And I'm sure that the state has done that in this case if they're getting that backlash from a witness who's not necessarily cooperating.
Right. All right, we're going to take a break right now on Law and Crime. When we come back, hopefully we'll take you live to Eric Boyd's trial. We'll be here. Stay with us. Okay, so we've been live in Eric Boyd's trial, and we've been listening to Timothy Shade. He's a fingerprint examiner, and he's been going through a lot of the evidence that he collected from the scene. This was mostly inside the home that this crew was renting out. He's pulled out a lot of different bags with different things in them. Most recently, we saw a sheet, we saw a blanket, some fabric, and a lot of this stuff was apparently in a trash can inside the house. Tara Walsh, what do you think of this witness so far? I mean, this is all very important. We need to see all this, obviously, because a big part of this trial is going to be the forensic evidence.
Right. So if I were the defense attorney in this case, it's already been clear that there were no fingerprints or DNA linked to this particular defendant. So on cross-examination, I would make it a point to go through every single item that was tested: the all-purpose cleaner, the gas cans, the pink fabric, the blanket, the sheets, and you tested all of these items, and did any of those items that were recovered by you or tested by you or anyone on your team, were any of those items linked to my client? And I would probably leave it at that.
Right, because they know that there was no DNA for this situation of that. So that for the defense would be a great move.
That's right. Keep it simple.
All right, so we've been watching Timothy Shade, and he is showing all of these bags of evidence, these pieces of evidence. He, again, is a fingerprint examiner, and he's been doing this for a while. It's getting to be quite lengthy here. Tara, why do this, and why actually, do it for this amount of time? Because this is something that is becoming a little bit monotonous. We've been seeing all these evidence bags pulled. He's explaining what each one is. Is the jury sleeping right now?
I would tend to think so, unfortunately. Anytime you have a forensic analysis testify, it does tend to get a bit tedious and cumbersome when they're dealing with all of these large physical exhibits. But the state's obviously presenting them for a reason, and the reason being they need these physical pieces of evidence in their case in order to prove all of the elements of the crime, at least from the state's perspective. One of the ways that prosecutors can try to keep it interesting for a jury, and you've seen her do this on a couple occasions, is actually publish the pieces of evidence to the jury. Typically that's done by a sheriff's officer actually handling the exhibit and actually getting up close and personal with the jury and showing them the piece of evidence. That's a way to keep them interested.
And she's showing items that no fingerprints were found on. Why is she doing that as well?
So I think what she's doing is she's anticipating the cross-examination from the defense, in which the defense attorney will be likely to question this forensic fingerprint examiner as to the fact that no fingerprints were tied to his client. So she's anticipating that that question's going to be asked, and what she's doing is she's trying to explain through this witness as to why there may have been his fingerprint missing. And what she did is she asked this forensic analyst exactly why fingerprints weren't able to be pulled from certain objects. And you heard him explain that due to either the texture of the fabric, I think he actually mentioned the garbage bag, that they weren't scientifically able to use their process in order to pull a print. So that's one explanation as to why his fingerprint, he may have touched this item, but his fingerprint wasn't able to be pulled for that reason.
Right. Okay, so we're still listening to the cross-examination of Timothy Shade. And the defense has been asking him a lot of questions about the process of how he gathers these, how that all happened, specifics about each finger and how many points of comparison can be drawn from a finger versus a palm, for example. Tara, what do you think of the cross so far? Is this effective? What are they trying to do?
So I think what the defense attorney is trying to do here is point out that this process is not purely quantitative, and that there's no exact science to match fingerprints or palm prints. And what he's suggesting is that it really is a subjective conclusion. And if it is subjective, then that leaves room for doubt, or certainly grounds to question his ultimate conclusion in this case as to who these particular fingerprints belong to.
Do you think that the cross-examination of him is doing well with saying, hey, this is a little subjective? You have about 30 seconds.
I think it is. I think he's certainly drawing and focusing the jury's attention on that fact.
All right. Tara, thank you so much. After the break, we'll continue to follow this trial live. Again, we have been watching the live trial of Eric Boyd in Tennessee. This is the man accused of a double murder of a young couple. Stay with us here on Law and Crime. We'll be back. Okay, so we've been listening to Patricia Resick here. Again, she's a former officer for the Knoxville Police Department, firearms expert, as she's been explained and qualified here on the stand. One of the things she was most recently talking about was the bullets that they found, and I'm understanding that it was determined that 2 of the bullets they found were fired from the same gun. Tara, when we're talking about the firearm here and obviously a murder weapon being tied into all of this, her testimony here is super important for the prosecution.
Right. Again, as we discussed earlier, they have to prove that this particular weapon was in fact the murder weapon. So the way that they do that is to actually test the casings and compare a bullet against the alleged weapon that was used. So what she did in the first instance was use that dummy cartridge and a dummy bullet to explain to the jury how she comes to her conclusion as to whether or not a particular bullet can be linked to a particular firearm. And the way that these ballistics experts do that is they fire the weapon, they do a test fire with a clean bullet, and then they compare the casing, that bullet and the markings on the bullet to anything that was found at the crime scene. So after she's done that from the stand and explains how one would go about that analysis, she's then coming in front of the jury and going through each casing, each bullet that was discovered at the crime scene and explaining her conclusion, her test fires with respect to that physical evidence.
And unlike the last witness we saw who went through some of this evidence and fingerprints part of it, this is a little bit more black and white. It's ballistics. How does the defense cross-examine her, or what do they do here?
You're right. It's more straightforward, certainly, than fingerprint analysis. It's not as subjective, although it is still based on one person's conclusion in examining the markings of the test-fired bullet. But still, I think in cross-examination, what a defense attorney can point to are all the conclusions that she cannot come to. Specifically, she has no idea what particular person actually fired the weapon, and that's probably what they would focus on here.
Right. So we just got a look into the testimony from Daniel Foster. Again, he was working with the state fire marshal's office at the time. He was on scene when they went to the scene with dogs and were able to sniff out the scent of an accelerant. In this case, I'm assuming that would be the gas, which they used, presumably used where Newsom's body was found. He talked a lot about how that process works, how the dog is actually the one that snouts out the areas, and then when the dog makes a gesture or goes crazy, they know that that accelerant has been detected. So really, really interesting here, because this is concrete, again, evidence that shows that this is good for the prosecution.
Yeah, I wouldn't consider him a very, material witness for the state. He's kind of setting the scene at this point, and I'm sure someone else who actually did the analysis will testify as to what the accelerant was, and if in fact it was gasoline, which we're assuming it is in this case, it's already been testified about, whether that accelerant can actually be matched to anything that was found in this gas can that was recovered from the car that he borrowed. There was other testimony in the case, I believe, from his cousin, who indicated that she had placed the gas can in the car because the car was continually breaking down. So that's obviously a weakness with respect to this part of the state's case, and I'm sure that the defense at some point will point that out.
Yeah, the cross-examination had just started when we cut out of it now. So what do you think the cross is going to be asking?
Well, I think they'll direct him towards the limitations of his investigation, and that he was really there just to collect evidence. He did not run any analysis on the ultimate accelerant. He did not draw any conclusions. He didn't draw analysis between the accelerant found at the train tracks to any accelerant that may have been connected to the defendant.
All right, so again, we've been listening to Russell Whitfield. He is a forensic officer. He has been talking about what he found and what he saw at the railroad tracks and the crime scene here. He's going through a lot of the fabric and these evidence bags and pointing all of that out and talking about all of this. Tara, so far today, you know, this has been a lot of forensic witnesses. We've seen a lot of evidence, and we heard a lot about guns. What do you think about today, the witnesses called by the prosecution?
So I think a lot of these witnesses are a setup for what's going to come down the line in terms of connecting these physical pieces of evidence that were found at the crime scene on the railroad tracks to the home, and also as to whether or not any fingerprints or DNA evidence, either from the victims or the co-defendants or this particular defendant, were found on any of those physical pieces of evidence. We haven't heard that testimony yet, but I would expect that that would be coming shortly.
And what about cross-examination for this witness as a defense attorney?
Again, you know, he's certainly not a material witness. He even testified to the fact that he's not familiar with arson. He kind of let the arson guys run the scene. He was just there to take photographs. So from a defense perspective, I think it's an opportunity to point out possibly any errors that may have been made by law enforcement in sending someone that's not familiar with arson to take arson photographs.
All right, Tara Walsh, thank you so much for joining us today. Plenty more on Law and Crime. Brian Buckmeyer is next. Stay with us.